really only got one of note. I'll talk about another case after, but Salguero Sosa out of the Ninth Circuit. I always like to talk about the Ninth Circuit on your show because you and I are both in the Ninth, and it's about past persecution. It's an interesting asylum case. The individual suffers from dwarfism, and he's an advocate for the rights of dwarfs in Guatemala. So definitely a unique case. And there's a whole bunch of reasons that he said he was harmed and he feared harm. And ultimately, the case got remanded back to the BIA and probably the immigration court. But the interesting reason for this, and I think it's really the Ninth Circuit that is at the tip of this spear, is that the decision reaffirms Ninth Circuit precedent that says for the persecution, for whether a non-citizen has suffered past persecution, the immigration judge needs to consider all harms cumulatively. And that is the law for a convention against torture. Mm-hmm. You have to consider all harms for torture cumulatively, and that's kind of because of some of the wording and the regulations for the Convention Against Torture. Not the same regs for asylum, but this is now the second or third Ninth Circuit case, and they're very clear in this case that even if, harms individually, separate harms, wouldn't rise to the level of persecution, you got to consider whether altogether it is. Mm-hmm. And if an immigration judge in the BIA fails to do that, at least in the Ninth Circuit, it's per se reversible error, it seems, and it's got to go back.
Damn.
It's something that I said on the podcast attorneys should be advocating for in all the circuits. It's certainly a non-citizen friendly standard. It seems intuitive to me. And so, check out, especially if you're in the Ninth Circuit, remember Salguero Sosa, and that the cumulative harm standard is required. It's really a good gotcha to get to the BIA on appeal, and certainly the Ninth Circuit if you end up at that far of a level. Another good gotcha from the same case is another reiteration of what the Ninth has said, and that is the nexus standard. That is the reason that the non-citizen suffered harm. It's got to be on account of a protected ground for asylum. It's got to be one central reason. So, the fact his political opinion or his membership in a particular social group must be one central reason for the persecution Mr. Salguero Sosa suffered to get asylum. Fine. But for withholding of removal, which is actually a higher standard, you have to show that there's at least a 51% chance that you'll suffer harm. It's actually a lower nexus standard. It just has to be the political opinion or the social group. It just has to be a reason, one reason among many. And it's this wonky issue that there's a circuit split about because of the actual statutory text. And it's this weird situation we find ourselves in. So know your circuits when you're, if you get a loss on nexus, know your circuits, know the law, because that's also a per se reversible error. The Ninth and the Sixth, I want to say, have the different standards. The Fifth doesn't. Can't remember who else doesn't. The First Circuit has flirted with it. I said it on the podcast when I was talking about the case. I can't remember at this moment, but it's just one of those weird immigration wonky issues that's percolating out there. So Salguero Sosa, very clear on that again in the Ninth Circuit.